Hello everyone, today I just want to talk to you about why you do not want to just leave it up to your beneficiaries and not have a will or a trust to divide or to distribute your property. Hi, my name is attorney Anthony Spratly. I'm the owner and founder of Genus Law Group here in Albuquerque, New Mexico, where we practice family and estate planning law. Now, you may say, or you may jokingly say, you know what, when I'm dead, I'm dead. I don't have to worry about my property. And you know what? You're right, you don't. And the folks that have to worry about it are your beneficiaries, right? What are they going to do with your property? And if you don't have a will, at a minimum, if you don't have a trust, it makes that process extremely difficult, right, to decide. And so if you die without a will or without a trust because you want your beneficiaries to duke it out, it could be a very costly thing for your beneficiaries, right? Because then intestate laws apply in the state of New Mexico. They may have to go to court and litigate how property is to be distributed, and it can get costly with attorneys, obviously court costs, going to court, and the protracted, the length of time that folks have to go through probate in order to close your estate. And if you don't have a trust, where the transfers of property can happen almost seamlessly because you have a trustee that will effectuate the transfer of the property from one beneficiary to another, then obviously if you don't have a trust, it makes that process difficult, because then you have to do what I talked about earlier, was to put the process through probate. Now, if you decide that, because you're going to be looking down from heaven laughing, watching the beneficiaries duke it out, you can make life a lot easier for them as you're looking down from heaven to make sure that they get what is allowed to them by state law, by devising a will or a trust. And a will can be a simple process that you can either write yourself and get it notarized and have witnesses involved. It doesn't take that much time to put pen to paper on what it is that you want to happen to the property upon your death. Same thing with a trust, right? A trust can be a formal document prepared by someone, a third party preferably. You can go online and get software as well to draft the paperwork, the trust work. I recommend against that. You want to work with someone to help you develop that trust so that you can properly assign the trustee and all the proper provisions and safeguards that you want in a trust to make sure that your beneficiaries are absolutely clear as far as what your desires are and what they were at the time that you were alive. So folks, I would not leave it up to your beneficiaries to duke it out. You have resources that are readily available to you that are pretty simple and relatively inexpensive to develop a will. Same goes for developing a trust and drafting and executing both documents. I think will save you a lot of anxiety when trying to decide how you're going to distribute property, and also will help out your beneficiaries, help them decide on where the property should go based on your intentions. All right, folks, that's all I have for today. Take care. If you want more information, you go to our website to get more information about estate planning. And you can also go to your Protect Your Success podcast at Apple Podcasts. Thank you. Have a great day.